Good evening, I'm Yolanda Nava. My co-host is Life and Times Tonight reporter Gay Yee.
Thanks, Yolanda. Our top story, are California HMOs changing their tune? Health plans across the state have agreed to an outside review process. Now that means for the first time, patients who are denied care can get an independent second opinion. And if the outside experts agree, the health plan will have to pay for the service.
The healthcare industry says the move is meant to reassure consumers who fear that medical decisions are based on money, not the patient's needs. But critics of managed care say HMOs are only trying to protect themselves, acting now before Sacramento passes even tougher HMO reforms, like allowing patients to sue their health plans.
Well, right now, most HMOs can't be sued for damages caused by refusing treatment. But there are exceptions to that rule, and one of those cases went to trial this week.
He was one of the best people that I ever knew. Always treated people with respect, always. Very gentle, hardworking, but fun, a good, really witty sense of humor, and so brave.
It's TERI Goodrich's turn to be brave now. The San Bernardino County kindergarten teacher is going head-to-head with one of the nation's largest health maintenance organizations, Aetna U.S. Healthcare. She's suing the HMO, accusing it of denying and delaying treatment she believes could have prolonged her husband David's life.
I'm doing it for Dave because we weren't able to do it while he was sick, and I think that they shouldn't get away with this.
TERI met David in the San Bernardino District Attorney's office. She was a victim witness advocate. He was a well-respected deputy DA. They were married in 1988. The future was bright until a day in June 1992.
David was speaking to Judge Leash and was going through his final calendar.
Leon Bogley was the bailiff that day in Department 5 of the Rancho Cucamonga Courthouse.
Without breaking stride, he told the judge that he would like somebody to call the paramedics. He was feeling very ill. He then slumped forward in his chair onto the desk, and he was very gray. You could see him go limp, and he completely passed out.
At first, they told us that it was probably a benign tumor. Finally, the pathology came back that it was this rare form of cancer.
On March 15, 1995, David Goodrich died. He was 44. TERI was left with a $500,000 medical bill and a major dispute with Aetna.
And I've got some new information on home therapist for you. It's amazing what a difference information can make.
She claims Aetna sold her husband a false bill of goods, that they delayed approval for cancer treatment, allowing her husband's condition to deteriorate. And she says Aetna refused to pay for special treatment from outside the health plan, even though Aetna's own in-plan doctors recommended it.
These people that were supposed to be caring for him would do the right thing, do what they had promised. And when they didn't, I think it just angered him to the core.
On September 12, 1997, TERI filed a lawsuit against Aetna Health Plans of California and its parent companies.
This case is an exception because it's seeing its day in court. Most Americans have no way of fighting back because most Americans can't sue. A federal law called ERISA says Americans with employer-paid health benefits can't sue their health insurers. But the Goodrich case is different.
TERI Goodrich can sue because as a public employee, she is exempt from the ERISA law, as are church workers. And so the case of Goodrich versus Aetna is now in a San Bernardino County courtroom. Aetna would not grant Life and Times Tonight an interview, but they did fax this response. It says in part, Mr. Goodrich's care, including experimental surgery, was paid for at all times when he followed planned procedures. Coverage was provided without delay. Aetna also points out extensive appeal procedures were in place with Aetna health plans. At no time were these procedures utilized by the family. But TERI's attorney says those procedures are inadequate, given the issues at stake.
We're suing Aetna for what's called insurance bad faith, essentially. It's where an insurance company or an HMO treats their own insured or member unreasonably by denying or delaying benefits.
Consumer advocates like Jamie Court believe HMOs are less likely to deny claims if they fear a big jury verdict from a lawsuit. He says he has video to prove it. This training video became public in an Alaskan lawsuit against Aetna. Court says it demonstrates that the company treats customers who can sue differently from those who can't.
Frank, there is a big difference between the ERISA plans and the non-ERISA plans. As a practical matter, you really may have to do more in a non-ERISA plan to protect against some of the exposures that we're talking about.
The insurers and the HMOs are very well aware of the shield of immunity. And ever since that shield went up, they have been treating consumers very callously. They have been treating claims that fall under ERISA differently than claims that fall under non-ERISA.
But there is an issue here that goes beyond the money.
If you could talk to the person who is making these decisions, if you could talk to these people, what would you say to them?
I would say you put yourself in the spot of every person whose life you are considering. This is a life you're affecting here. What if this was you? What if this was your child or your loved one? And then you need to make decisions that are right, that you would want made for the people that you love.
While opening statements in this trial started today, it is one of the few times that an HMO will have to take the witness stand. Joining us now to explain why this case is so unusual are Mark Hippler, an attorney who represents patients denied care by their HMOs, and who also served on the state task force to improve managed health care, and Keith Bishop, who was also part of that task force, and he is the former commissioner of the state agency that regulates HMOs. Gentlemen, thank you for joining us. I'd like to start with you, Mark, just explaining ERISA. So many people don't even realize that they don't have the right to sue.
That's right. 1974, this law came about to protect small company pension plans as an employee benefit, saying that if anything happens, you should only be able to sue for the amount in your pension plan.
So, for instance, if you didn't get a mammogram.
Correct.
And you ended up having breast cancer,
right.
What can I sue for?
Right now, your family, who's left behind because you've died because someone tried to save money, can only sue for the $50 mammogram. And in effect, it's given large companies, billion-dollar companies, a real license to steal from people and has allowed them to escape all accountability for their actions.
So, Keith, what do you think about this?
Well, I think this is really coming at it from the wrong direction. What we have is litigation, which I think is what you do when everything else has broken down. And so the real problem is try to fix the problems before they break down. And the way to do that is to come up with a system that gets these problems resolved fairly, quickly, and finally, so that you never have to get to the lawsuit stage. Consumers don't want to go through the agony of a lawsuit and the uncertainty and the expense of a lawsuit. What they want to do is get their problem fixed. So that's why I think the focus should be on a fair, fast, and final resolution of consumer problems so that we don't get to the lawsuit stage.
But these people feel that if they can't sue, they can't make the HMOs listen.
Well, there are currently a lot of procedures in place. I think they are inadequate. I think they need to be improved. But all plans in California are legally mandated to have a grievance procedure in place and to tell their people about their rights. And when I was Commissioner of Corporations, I fined over 80 plans, over $1 million for failing to properly tell their consumers about those rights. And what happened after we fined these plans and they started making the disclosures, we saw that the calls to the Department of Corporations 1-800 hotline number more than doubled. So I think as consumers become aware of these rights and exercise these rights, the plans will respond.
Well, Mark, do you think this is truly realistic?
No, not at all, because again, a billion-dollar industry only responds to a proper club. And in my sister's own case, where it was the largest verdict ever, an $89 million verdict, again, it was a very rare case. But because of that, we've had 160 patient denials of treatments, life-threatening issues, bone marrow transplants, liver transplants, and we've only had to litigate 3 of them. But we had that alternative, and I agree with Keith, it should be the last resort. But a patient without that opportunity can't ensure that any of the process is going to be fair if they don't have that final club in their back pocket to use as a last resort, which is a lawsuit.
So what about this idea of this external review board?
Well, external review boards work if there is something else behind them, and they can have the potential to work. But when you look at what you're fighting for on the front lines is coverage for a benefit that was promised to you when you're well, but you need when you're ill. And the external review boards, we don't know who's going to be on them. We don't know if that's going to be fair. And secondly, they're claiming right now, this one that came out today, that they will not deal with coverage issues, only medical issues. And yet one of the biggest gaping holes in these HMO plans is a exclusion for medical necessity care. So it takes a coverage decision and it takes a medical decision, and once again the HMOs are volunteering for this only after fearing that they might be held accountable for their actions and that they will not be able to stand up to normal scrutiny that every other corporation faces.
Well, Keith, what do you think is truly realistic? Because they have tried to make this happen at the federal level and also at the state level, trying to allow other people outside of government workers and church workers to be able to sue, and it hasn't passed. The politicians aren't going to let it happen, or at least not yet. So what's going to be the compromise?
Well, I think part of the compromise is what we see with the California Association of Health Plans proposing this review process. This review process undoubtedly is going to need a lot of improvement, and that's going to come. But I do think that we have to be worried about the consequences of making HMOs liable. It sounds good, but you got to be careful that you'll get what you ask for. If HMOs are made liable, you're going to see consumers hurt. First of all, costs are going to go up. You're going to see consumers lose coverage. Right now, 1 in 5 Californians does not have health care coverage.
It's not
and so improving the coverage for the few is going to leave a lot of people behind.
Mark, Keith, thank you so much, and thank you for joining us. Up next, we'll meet a present-day knight on a very personal crusade.